Okay, so good morning, guys. Today we are gonna kind of wrap up, hopefully anyway, I'm gonna move all of your faces though so I can see you all. So we're gonna wrap up talking about agency, and hopefully nobody else logs in, otherwise I might miss them. All right. By the way, fun factoid for those of you who don't know, the best bacon in Alexandria is from Downtown Diner. Okay, just so you know, that's the only place in town that deep fries their bacon. Fun factoid. So if you're ever bored and you need a breakfast date, you call me. But my first choice is always going to be Downtown Diner. Plus, Cindy is there, and Cindy's super snarky and like will hit you with the menu if you talk back to her. It's just like being at home. It's my favorite. Um, all right, so this is what we're trying to do. I get distracted talking about bacon, so. All right, and Chris didn't want to see us anymore or want us to see her. CBR demo, this is where we were. All right, so let's take a look at the agency form. All right, so wrapping this up. Well, at least hopefully, right? So last week we spent the 30 minutes talking through basically page one here and trying to break through most of the initial terms of when you use this, why you use it, because some tips and tricks on getting people to sign it, right? Or at least acknowledging it, and away you go. We talked through the seller broker or the buyer's tenant relationship. We also then, if you guys remember, we talked through how these are commonly put into kind of two sections, right? Let's see here. The first section that we really talked about, I'm going to go backwards, right? So each one is going to sort of talk about the dual agency component, right? So what happens if the broker is working with somebody in that other section. And then everything's going to talk about the material fact disclosures and what your obligation is, regardless of the fact that we don't have an agent material fact disclosure sheet. We still have to talk about it. And then the first section is really just identifying kind of the role that's being highlighted. So as far as this goes, each one of these three sections appears in all of these, right? Now, as we walk through the seller broker and the buyer broker, what we'll do is kind of dive into the dual agency side of the relationship. Before I do that, does anybody have any questions, or did anything come up along the way that you're like, oh man, I really wish we would have talked about this, or I have a question on this? Is there anything standing out before we dive in here? Seeing nothing. I feel like Ashley's judging me as she's sitting there eating her breakfast, but that's totally fine. All right, let's dive in here. Dual agency. So dual agency is the understanding that the broker represents, all right, and that's a key word, the representation side right here. This is a very big word that we're going to make sure we hang on to. Both the seller, the landlord, and, okay, another big word, and the buyer or a tenant. So dual agency occurs when one broker or salesperson represents both parties to a transaction. 99% of the time, this is what you're going to be really paying for, right? This is what you're going to discuss. This is going to be the high level as you're walking through this form. You're going to say, hey, by the way, dual agency occurs when we represent both you and somebody else in the same transaction. Okay, not a bad thing. Sometimes it's actually a good thing in single family residential. Or when two salespersons licensed to the same brokerage each represent a party to the transaction. Now, this is where we get this is what actually, I'm going to be honest with you, is trying to be lobbied to be changed. Because you get into a situation, right? So like, let's say Mitch Swenson has a listing, and I'm going to say Lucas was willing to drive to Crosby, right, to sell a $4 million property, because I think we'd all be willing to drive to Crosby to sell a $4 million property. Plus, their diner's really good downtown. Their bacon is not as good. And some of us are trying to learn how to mountain bike. That's my new thing. Anyway, so when you're willing to go, the tricky part is, though, is that agent has no idea. Lucas and Mitch, different offices inside the same transaction, they're still considered a dual agency. They're not allowed to lobby and advocate for each client, at least not to the detriment of either one. Versus, this is just FYI, at the state level and some other states around the country, they've gone to what they call a designated agency. not dual agency, designated agency. So designated agency, the difference is, and this is FYI, okay? You can just let this go in and out. You don't have to write notes or anything. But a designated agency role says that in this situation, Mitch would have the ability to advocate and advise for his buyer, or excuse me, his seller to the full capacity that he could. And Lucas could also advocate and advise his buyer to the best that he could, all the way. Now, the reason you can do that is because there's, you start talking about some of the larger brokerages, right? Like take Coldwell Banker and the Metro, right, are owned by the corporate side. Well, for instance, if you got one person in the Woodbury office and one person in the Maple Grove office, those two people probably don't even know each other's names, right? They probably don't even understand the same markets out there. Maybe they're both trying to buy something in Brooklyn Park. Who knows? Point being is that the chances of confidential information crossing paths is really unlikely, and even more unlikely in today's age when we're so digital, right? Like all that information, all of our notes and everything like that, very few of us still keep it in a form where we're going to cross paths and you could use it to the detriment of somebody else. So dual agency is hard because you can't actually go and advocate on behalf of your client. You're stuck not doing anything to the detriment of your client or somebody else's. And so that's where we're trying to look at this designated agency piece, but we haven't got it out of committee at the legislature level. Because remember, that's a state statute, like that's Chapter 82 license law. So that has to be passed by the House, by the Senate, and then signed by the governor in order for that thing to actually be changed. And so we keep lobbying for that because designated agency is what we should have, which would allow you and me and everybody else to advocate. If we have an in-house transaction, we can advocate for our client because it's very unlikely, right? Like if Amy and I have a deal, it's very unlikely that I'm going to know that Amy's seller is willing to go, $10,000 lower than they listed. The chances of me knowing that are really slim. Right. So that's where we should be able to advocate and advise instead of saying, sorry, I can't guide you on what to offer because I represent, the seller in this conversation as well. So just something to kind of throw at you. But as of right now, dual agency, even when it's two salespersons licensed to the same broker, each represent a party in the transaction. Now, dual agency does require the informed consent of all parties. So you'll notice that on your buyer contract and your listing contract, there's a section that says they will or will not agree to dual agency. You will also notice that in the purchase agreements, there's a section that says the buyer and seller will or will not agree to dual agency. Now, some people, some people think that in the purchase agreements, that section of the PA has to be filled out. The answer is no, it does not. If there is not dual agency, it does not have to get filled out. However, if it is dual agency, then it does. Now, if you go through Authentisign, which is going to get a big refresh, by the way, here, and the new interface looks really good. But if you work through that, then it'll actually auto-populate signature blocks in there. So as you create something in Transaction Desk and send it for digital signatures, you need to make sure that you're going through and actually removing or deleting those signature blocks on dual agency because it's not effective, right? And frankly, it makes you look like a silly agent, and we don't like silly agents. We make fun of silly agents. So you can tell I've been hanging out with my kids a lot this weekend. So that's where we have those conversations and make sure that you know that the consent, the informed consent, which means signatures, right? That's where you have to get that in writing. So dual agency requires informed consent of all parties and means that the broker and salesperson owe the same duties to both parties. And we're going to talk about what the fiduciary obligations are later, but that's where you owe the same thing. This role limits the level of representation the broker or salesperson can provide, and this is the phrase that I always use: prohibits them from acting exclusively for either party. Or what I will often say is I basically say this is when I or somebody in our office or company is going to represent the other side of the transaction. Here's what that means is that I can't do anything to either party's detriment, right? I can't do anything that's going to hurt you or hurt the other person. So, last week we talked about even just doing open houses, right? And getting the consent signed on which role you are. And the default role, even if you walk into any listing with Coldwell Banker Crown Realtors on it, that you are obligated to represent the seller at that point. That's part of the value add, right? Of being with a company that has hopefully a lot of listings, not right now, but normally. Okay, so when we walk through that, that's one of the values is that you have a lot of clients that you're already representing. So like I said, when you're newer to the industry, or if you're in the midst of a down season, right? If you're cyclical and life happens, right? And you're ramping back into the game, you can use and leverage the brokerages information in order to continue to move forward. So there's a lot of great things that you can do by understanding that you represent everybody there. So that's part of the good side of it. So in a dual agency, confidential information about price, terms, and motivation for pursuing a transaction will be kept confidential unless one party instructs the broker or salesperson in writing, notice that phrase, right, to disclose specific information about themselves. Okay, so an example of this would be, so if Ashley and Danny have a deal going right now, and Danny's got a listing that Ashley's selling, and Danny's seller says, hey, you know what, we're in the middle of negotiations. I know you guys are in that dual agency thing that you explained so well to me, but you know what, I don't really care. Let them know that I'll sell for 10 grand less. Oh, okay, right? Danny says, hey, that's super cool. Let's write that down real quick, and then I need you to sign this piece of paper that says you instruct me to inform them that you're willing to send for 10 grand less, right? And the reason we do that is protection for you guys, right? You want to protect yourself so that in case this person, maybe is not mentally stable, either clinically diagnosed or realtor diagnosed, clinically unstable, right? Then you have something in writing that allows that person to, that you can go back to say, no, remember this conversation we had, here's the date, here's what you signed saying that I could tell Ashley to tell her clients that you would sell for 10 grand less. Right? Or you start talking about motivation. Hey, I really need to move. I'm starting a job. Can we push this closing up? Great. I can tell them that, but I need that in writing and disclosed so that everything's hunky-dory. Does that kind of make sense? Okay. So that's where you talk about when you start releasing those price, terms, or motivation, any of that information, when somebody says motivated seller, that's an irritant of mine. Okay. Every seller is motivated because they have their property listed. That's dumb in my opinion. However, understanding the industry and the phrasing of it, especially culturally, right, in greater Minnesota, we start to look at that and say, okay, usually that means they're willing to take a lowball offer. Instead, I always say, why not just lower the price if you're motivated? Either one of the things is going to show the market, and we did give away less of the farm. But anyway, so when you look at it, you can say, but if somebody says, hey, can you put motivated seller on the listing? Yes, I can. However, I need that in writing. So if you're at the listing table, right, and you're signing it, just in the other section, right, seller instructs broker to disclose they are highly motivated. Period. And then you can sign it inside the document, and then you still have it in writing, and everybody's agreed to the terms of that. Okay. So anytime the seller says, hey, I want you to do this, I want you to do this, and you start hearing price, terms, motivation, right? You start hearing those three, that's when you can start to have that conversation about going forward. So it's basically just get it in writing. That's the bottom line. Okay. All right. Line 42 again, other information will be shared. Okay. Notice that that's a standalone sentence, right? So unless everything will be kept confidential unless one party instructs the broker or salesperson in writing to disclose specific information about themselves. Again, this is talking specifically about price, terms, and motivation. Other information will be shared. Okay, so a lot of that's just the standard information that you're going to learn from disclosures, public records, and things like that. So basically, when it comes to a dual agency situation, you just want to know that price, terms, and motivation are all kind of coveted language that you must keep confidential. And so like it can happen. Like I'll pick on Ashley a little bit. She's got a really nice townhome on Lahamadou, right? Well, it is a nice townhome. Don't give me that look. Okay, it's a nice townhome. We had a conversation 6 times about how it's been overpriced. We're now correcting that, right, Rambo? So what I know though, right? So I've had that conversation, but now that they're going to lower the price, if I know some more information about that buyer because of the relationship or the conversations that Ashley and I have had about that transaction, right? So now if I get a buyer who says, hey, Brandon, I want to go look at this thing, I got to remember that at this point in time, I represent the seller until I get that buyer under contract. Okay. So now I have to hold all that information about price, terms, and motivation because I met the sellers with Ashley. We walked through the property. Like I have inside information, which is not uncommon for you to obtain. Right. So when you know that, if I was to go show that property, I have to keep that, pretty close to the chest at this point in time. And then even if I get them under contract, that is still confidential information unless Ashley can prove to me that the seller gave us as the brokerage, right, written consent to share their motivation level. Like, hey, we really need this thing gone by the end of the year for tax purposes. I don't know if that's a true statement. Okay, just for clarity, that's a made up thing. But like there are people who need to sell their second homes and their investment properties for tax reasons, right? So like if they say, I need this thing closed by the end of the year, do whatever you got to do to make that happen. That's highly motivational information, right? We're going to get that in writing, and we're going to get that signed. We're going to put it in your file, and you're going to turn that in, right? You're going to turn that in so the brokerage has that copy of that file as well, to make sure that we are all in agreement on that. So otherwise, that other information, it can all be shared, right? So there's nothing else out there that has to be kept confidential except your price terms and motivation level. Now, some other people, you can choose to keep confidential what you want. Some people think that you have to keep everything confidential. No, you don't. Not if you have been given consent in order to do that. Finishing out line 42. Dual agents may not advocate for one party to the detriment of the other. Okay. So that's kind of the phrasing there that is most of the time what I use. Like, because you'll get some people who are like, yeah, I don't care if it's a disclosure, I'll just sign it for you. This is the primary language that I'll use. Hey, I represent both sides, me or another agent in the company, and we can't do anything to the detriment of another. And everybody's like, oh yeah, okay, that makes sense. And then we move on, right? Now, within the limitations described above, dual agents owe the seller and landlord and the buyer/tenant the fiduciary duties described below. Okay, we'll get to that. Dual agents, notice here's those fiduciary obligations, right? So this would be section 2. Okay. Dual agents must disclose material facts. Notice there's section number 3, right? Must disclose material facts is defined in 8268 subsection 3, of which you, the broker, is aware of that could adversely or significantly affect the buyer's use and enjoyment of the property. Again, a reminder, does not apply to lease or rental transactions. So you see dual agency, the first section of dual agency in this one, as we break these down, is significantly more expanded because it's complicated and it's irritating. But dual agency is very, very important. Now in the residential world, it's not uncommon for dual agency to happen. In fact, we like it. In the commercial world, it's rare that dual agency will happen because commercial is a little bit more cutthroat because it's all numbers based. There's no emotion involved in it. And so when we get into the commercial side of it, a lot of times, especially in the bigger deals, somebody doesn't want the same person representing and fighting for them because you could be talking about 10, 20, 30, hundreds of thousands of dollars in a difference, right? Whether it's in repairs, asset transfers, liability releases, you name it along the way. So that's where usually in the higher end commercial space, nobody has dual agency. In fact, it's super rare. In the rural markets here where we're dealing with the, I'm going to say less than $1 million commercial properties, it's possible for you to have both sides of those. And some people specifically hold properties just so that they can do that. And some people even like to think, well, in that situation, the listing agent probably knows the most about the property, so they want to go directly to them, which is also not always true, but that's how it's broken down. So dual agency, very common in our market spaces. Especially I'm just trying to think, like Morris, Crosby, even the smaller communities, that's even more common, right? Because people just know you. They want to call you because your name is on the sign. They want to call you. So it happens, and it's great. Hog the thing. Have a great day. Just make sure you're not, violating any license law. Any questions on dual agency before we move on to facilitation? Did you learn something new, or am I just blabbing on about stuff you already know? Lucas learned something, Ashley's ignoring me, and Amy's just smiling at me like a proud mama bear, which I appreciate. So, all right, let's go on. Facilitation. Okay, so facilitation. Ooh, ow, my knee. This is the sign of an age, getting old there. Okay, a broker or salesperson who performs services for a buyer, seller, and does not represent either in a fiduciary capacity as a buyer's broker or a seller's broker or a dual agent. Okay, so that's kind of the first high level section. What is a facilitator? We had a lot of facilitation deals in quarter 1 and quarter 2 this year. We did a lot. I should have actually pulled the numbers, but I would say it's more than we have ever done before as a company. I want to say I think we did like a dozen plus each month the first couple quarters. The downside is we don't get paid that much. But it's still a way to make money. It's still a way for you to build relationships with people too. And that's why we like to use it. So the facilitation side, when you start thinking about, hey, I want to sell to my cousin's third niece twice removed. Okay, what do you want me to do about it? Do you want representation? Do you want me to guide you, advise you, and counsel you? Or do you just want me to fill out the paperwork and hand something to you at the end so the lender's happy and you can take something to a title company? I want the latter. Totally fine. Now, Usually, we at one point in time had a minimum standard, and I just haven't enforced it because I don't know that I agree with it. Because really, we're about helping people, and sometimes helping people means you do things for no money, because it's just the right thing to do. So. We try to get $1,000 out of these. That's kind of like my baseline. Like if you can get $1,000 off a facilitation deal, we're doing okay. And some people can be like, well, I can go to my attorney and they'll do it for $500. That's totally fine, right? If you feel if you feel your value is there, and this is where you're going to kind of feel it out. Like if you know somebody really well and you know that it's going to take 2 hours for you to sit down, fill something out with somebody, and you're going to get paid $500, do it, right? Like I'm not against that. But if you know that this person's going to require a lot of hand holding, they're going to call you and ask you a bunch of questions. They basically think you're representing them when you don't. Either A, you have to have really good boundaries, or you charge a lot more, right? The tricky part here is that oftentimes we ebb and flow from facilitator to full representation, and we're not really good about putting up that wall. I'm really good about it when I don't know the person, just because they could be a Department of Commerce spy for all I know. But other than that, if it's somebody I know, I might ebb into, here's a thought you might want to consider, right? Here's some advice, here's some counsel along the way. So the facilitator, okay, at line 51 here, the broker or salesperson does not owe any party any of the fiduciary duties listed below except confidentiality, unless those duties are included in a written facilitator services agreement. So if you decide to do a facilitation, you still have to sign a facilitator services agreement, okay? That facilitator services agreement will specifically outline all the items that you're going to do for somebody. Okay, buyer or seller, you can't facilitate both in a transaction. You can only facilitate for one party. Okay, nor can you represent someone and facilitate for somebody. You can't do that legally. That just doesn't work. So you can be a facilitator in a transaction, and then you're out. Now you can facilitate on behalf of somebody, and if the other side of the party wants to go hire another facilitator, that's totally fine. But it's kind of weird. But they can do it. So. It's important to know too, this is the default role in the state of Minnesota is a facilitator agreement, right? So if you meet somebody at an open house or somebody calls you and like, hey, can you go show me this house? Yes, I'd love to. Hey, welcome to the open house. Welcome. If they start telling you things, you are held to confidentiality. You don't get to talk about that. However, it being the default role, this is the role you remain in until you sign a representation agreement or a service agreement, such as a facilitator service agreement. So when we start to look through this, and maybe this is a form we can go over later, but the facilitator services agreement, it'll say, you're going to put a sign in the yard, you're going to put it in MLS, you're going to negotiate purchase agreements, you're going to send it to the title company. It walks you through all the high level stuff in order for you to understand what your job is, which is why it's nice to use that. And again, that's on the buy or sell side, not both. Okay. So the facilitator, broker, or salesperson owes the duty of confidentiality to the party, but owes no other duty to the party except those duties required by law or contained in a written facilitator service agreement, if any. In the event a facilitator, broker, salesperson working with a buyer/tenant shows a property listed by the facilitator, broker, or salesperson, okay? So I'm just going to remind you, you are talking to, Uncle Eddie, and Uncle Eddie says, hey, can you show me that new listing that you just put up? We'd like to really do that because maybe you helped Uncle Eddie sell his house to his neighbor on a facilitation agreement, right? So now you're bringing Uncle Eddie to one of our company's listings across town. That's the situation here, right? So it's important to know then the facilitator, broker, salesperson must act as the seller's broker. Okay, so at that point, you're defaulting back to representing the seller of that situation, not Uncle Eddie, even though you have a facilitator services agreement. Doesn't matter, right? So if he, I guess, does that make sense? That's what I'm trying to say. The seller is going to trump that because we now have a formal relationship with them. We want to make sure that we're honoring them, and state law says that that's what we have to do. Okay. So the facilitator, broker, salesperson must act as the seller's broker in that thing. If you got questions on that, you can see page 1. In the event a facilitator, broker, salesperson working with the seller landlord accepts a showing of the property by a buyer tenant represented by the facilitator, then the facilitator, broker, salesperson must act as the buyer's tenant broker. Okay. I'm going to read that again just to make sure you get it. Okay. Because I saw some faces. In the event a facilitator, broker, or salesperson working with a seller, okay, accepts a showing of the property by a buyer being represented by the facilitator, broker, or salesperson, then the buyer must act, or the facilitator broker must act in the buyer's best interest. So it's the same type of a relationship, except for it says if you're facilitating a deal, like you put the thing in the MLS for somebody, okay? You put the listing in the MLS for somebody. That's in the facilitator services agreement as a checkbox. Okay, so we put in the MLS. Showing management, you check that one. We're going to handle showing management for you too. If we accept it, but now our brokerage comes in and is representing that buyer into that facilitation of the listing of a facilitator services on a listing, that buyer contract trumps the listing contract. So now we are giving all duty to the buyer over the facilitation. Does that make sense? Okay, so when in doubt, just remember that if we have a full representation contract and somebody walks into us as a facilitation thing, whoop, we're going to trick that thing all the way up. Facilitation services on a listing side are really, really rare, right? It's very rare that we're going to put something into the MLS and use our marketing power without getting full value for it, because that's one of our big value adds, right? Is our marketing prowess. Us and the Coldwell Banker Network pushing everything out to about 400 plus different websites. That's a huge marketing push, and something we need to be very, very cognitive of. So that's part of the big side of why the facilitation matters. But you have every right to facilitate, but you can only facilitate one side of the transaction, and you need to make sure that you have a facilitator services agreement signed. Otherwise, there's nothing that says you can't get paid, right? So that's kind of where we're looking at with that one. That being said, okay, apparently it's going to take us 3 Mondays to get through agency because I talk a lot, right? And I want to honor your time at 9:29 as I see over here. So next week, what we'll do is I got to get rid of this. So next week, we'll kind of walk through and finalize the fiduciary obligations that we owe people, and then we'll walk through the predatory offender notice. So next week, likely it won't take 30 minutes, but we'll walk through that in part 3 of our agency piece here. Any questions on the 2 sections we covered so far? I don't know if we started late or if I just had a lot more to say. I know dual agency takes a lot though. Questions?
So you can only facilitate one side of something?
Yes.
So if I'm facilitating the seller, they can bring the buyer, but I can't write anything for the buyer?
Depends. So if you're in your situation, Danny, if you're facilitating for the seller, okay, the facilitator service agreement is going to specifically outline how many services you are providing for the seller as part of that, right? But the only fiduciary obligation you owe is confidentiality, okay? So if one of them is, you're going to put it in MLS, right? That's where you would come back and you would say, okay, well, I'm going to put an MLS, but now you get a showing, right? So really this is now that second section right here, okay? So if you get a showing request and now you have the buyer represented under contract too, and you bring the buyer into that listing, now your representation of the buyer's representation agreement is going to trump your facilitator services agreement. Right? So this is where when we facilitate for people, that's where this form becomes really handy because it very clearly, okay, it articulates if you hire us to come in, when your services are going to be diminished because of our sheer size and scale, right? Chances of us bringing a buyer to your listing that we're helping you with is very likely. Same thing. If you say, hey, I'm going to sell this, or I'd sell this is one of my favorites. I'd sell it if you bring me a buyer. Okay, well, that's fine. Uncle Eddie says, yeah, I'd sell my house if you bring me a buyer, right? Totally fine, Uncle Eddie. I'm going to bring my contracted buyer and show him your house because I know it's a perfect fit. Now you have 2 options there. Number one, Uncle Eddie can sign a full listing contract with you, right? A full representation contract with you. And then you can enter in as a dual agency. Okay. Or you can leave Uncle Eddie unrepresented and you can represent the buyer, and your obligation is to represent your buyer. Therefore, you can write the purchase agreement. You can get the disclosures. You can say, hey, Uncle Eddie, I need you to fill these disclosures out because my buyer needs them. In Chapter 82 license law, and Chapter 562 of the Minnesota State Statute says that you have a material obligation to disclose defects on your property. So since it's the law and my buyer wants them, I'm giving you these forms to fill out and return to us, right? So you're advising and you're working on behalf of your buyer, which sometimes feels in an unrepresented seller situation can sometimes feel like you're representing the seller, but you're not giving any advice or counsel. You're simply saying, here's what needs to get done and I need it back. Here's the purchase agreement. Here is our offer, Uncle Eddie. I will walk you through it. I will answer questions, but I cannot advise you. That makes sense? So that's where facilitation is good and it's helpful, and it still allows us to build relationships with people and hopefully be that agent for life here. And it allows us to be, transformational instead of transactional. But there is a limitation in what we can and can't do. Does that answer your question, Danny? Okay. Chris, did I puzzle you?
No.
Okay.
No, I was just thinking, we have a lot of people that come in and just want, hey, just write up the contract. And you've got the buyer and the seller.
Yep.
So agency only then, or what do you do with that?
Great question. So and this does happen quite a bit. You can't do anything without an agreement, right? Mm-hmm. So does somebody want full representation here? No. I mean, it's my grandson, for crying out loud. I just want to sell him the house, but he needs a purchase agreement for his lender. Mm-hmm. Totally fine. So here's what's going to happen. I can't write anything or help you unless kind of like an attorney, right? You need to engage me in some way. We need to have a formal engagement letter here. So what that's going to look like is I'm going to give you a facilitator services agreement. Somebody's going to have to sign this so that we are in an agreement on how we're going to get compensated, right? And you say, we charge $1,000 for drafting contracts and giving you access to all of our forms and everything else and sending you out the door. Okay, that's fine. Yeah, we'll pay it. Well, can we both pay it? Sure, you can both pay it. I don't even care. Somebody has to sign the facilitator services agreement. Which side? 9 times out of 10, it's going to be the seller. Okay. So the seller says, yep, I'll sign that form. Super cool. So the seller signs the form and away we go. Now at that point, we start to have the conversation, say, all right, so we're going to fill out the form and then you're going to go through the facilitators. You're going to go agency, both parties, right? Because again, if you remember last week, Minnesota state law, early on in any real estate transaction with material facts, you have to disclose this thing. Both parties are going to sign agency. Facilitator service agreement is going to come out and it's going to work with the seller. Okay, hey, Mr. and Mrs. Seller, here's what we're going to do. I'm going to check this box, which says I'm just going to draft the purchase agreement for you. That's what we're doing today, correct? We're all in agreement. Excellent. Sign here. And now we go. Now I pull my purchase agreement out. All right, Grandma and Grandpa, what do you want to sell the property to for your grandson? $1. Sounds great. $1. Tell me when do you guys want to close on this thing? Can we do it tomorrow? Sure. You'll have to talk to your title company to make sure. So I'm going to just put on or before, and give him 2 weeks, right? Or whatever. So that's where even that was a bad example because that's giving advice and counsel, right? Because you're using your expertise. But essentially you're going to walk through the form line by line. It's a yes, no question on what they want to do. And then you hand it to them, copy it, sign it, make sure everything is legal, send it off, right? And that's all we're doing at that point. So agencies on both sides, facilitation on one side, because you can't do a facilitation and representation in the same deal. So it's right. One or the other. And then away you go. And then in the purchase agreement, so what you would do in this example, like let's say, grandson and grandpa are said, oh, we'll split the fee $500 each. Totally fine. What you would do is then just write on the purchase agreement, the seller to grant a $500 concession. Right. So then that's how you're balancing that out. Otherwise, if you really want to follow up and get in the weeds, then you can call the title company when you send it over. But now you're going beyond your facilitation services agreement, right? Because you don't need to do that unless you check the box, right? Okay. This is fun.
Yeah.
Oh, I love it. All right, you guys, I'll let you get going. So next week, 9:00, we'll finish this thing out, and then we'll move from there. In the meantime, if you guys got questions or comments, if there's a forum you'd like to see us go through next, feel free to let me know. Otherwise, like I said, we'll just kind of keep this as a standing opportunity until people no longer show up. So hopefully it's helpful. And if not, at least I got to see your beautiful face for 36 minutes. So have a great day, you guys. We'll talk to you later.
Thanks.
Bye.